Hi everyone, and welcome back to Flow Migration Law. I'm Jay, your principal migration lawyer. Today we're going to have some real talk about a topic that causes a lot of anxiety for partner visa applicants: visa refusal. No one wants to receive the news. But the good news is, by understanding what visas get refused, you can proactively prepare and strengthen your own application. So let's get to it and discuss 5 critical refusal reasons and how you can address them head on. So let's count them down. Critical reason number 1. The applicant didn't meet the strict definition of a spouse or de facto partner, or very commonly, the relationship evidence wasn't strong enough. You might be in a genuine relationship, but if you don't provide comprehensive proof across all 4 pillars, financial, household, social and commitment, the department can't be satisfied. Or perhaps you haven't met the specific criteria, like the 12-month cohabitation rule for de facto partners. Now this comes back to what we've discussed in our videos. Meticulously gather diverse evidence for all 4 pillars. For de facto, if you haven't lived together for 12 months, ensure your relationship's registered. Don't just tell them. Show them your relationship's genuine and continuing. Reason number 2. The Australian partner wasn't actually eligible to sponsor. This can be a real shock for couples. There are certain limitations on sponsorship. For instance, a sponsor might have previously sponsored another partner within a certain time frame, or they may have been sponsored for a partner visa themselves too recently. There are also character requirements for sponsors in some situations, especially if there are children involved. Before lodging, it's crucial to check the sponsor's eligibility carefully. Understand the sponsorship limitations and obligations. If there have been previous sponsorships, be very clear on the rules. Honesty from the sponsor about their history is key here. Reason number 3. This is a big one for onshore applicants. Applying at the wrong time or from the wrong location, leading to Schedule 3 criteria applying. If you apply for an onshore partner visa when you don't hold a valid substantive visa, for example, you've overstayed a previous visa or you're on a certain bridging visa, extra criteria called a Schedule 3 kicks in. These are notoriously difficult to meet. The best way is to always try and apply for your partner visa while you still have a valid substantive visa. If that's not possible and you find yourself needing to meet Schedule 3, you must provide compelling and compassionate reasons for why you should be granted the partner visa despite your circumstances. This often requires very strong arguments and evidence, and I'd strongly recommend getting legal advice if Schedule 3 applies to you. Reason number 4, not responding properly or at all to a Section 56 request for more information, often called an RFI. The department might need clarification or additional documents. They'll issue an RFI with a strict deadline. If you miss this deadline, provide incomplete information, or the information doesn't address their concerns, they can make a decision based on what they have, which often leads to refusal. Take any RFI very seriously. Understand exactly what's being asked for, provide thorough, accurate information and documents within the specified time frame. If you're unsure how to respond, seek advice immediately as the deadline is crucial. And critical reason number 5, failing to meet the health or character requirements. All applicants must meet certain health criteria to ensure there won't be a significant cost to the Australian community or risk to public health. Similarly, there are character requirements and certain criminal convictions or associations can lead to refusal. For health, be upfront about any known conditions. Sometimes a health waiver is possible for certain visas if the condition is significant, but this is complex. For character, declare everything honestly. Obtain police checks from all required countries early. If you have any concerns about either, it's best to discuss it with a migration lawyer before you lodge. Facing the possibility of a visa refusal is daunting, but understanding these common reasons can empower you to build a much stronger application from the start. Many of these pitfalls are avoidable with careful planning, honesty, and attention to detail. If you're worried about any of these issues in your own application, or if you want an expert review to minimize your risk of refusal, please reach out to us at Flow Migration Law. We're here to help you guide you through the complexities. You can find our contact details on our website, linked in the description box below. And if you're building your case, be sure to check out our success stories on our website for some inspirations and to see how challenges can be overcome. If this video has helped you, please hit that like button, subscribe for more essential Australian immigration information, and share it with anyone who might be on this journey. Thanks for watching, and I'll see you in the next video.